The lawyer in me arranged that introduction with the flashing lights and the swooping siren. But I'm here not just as an attorney. I have two grown daughters who've gone through the public schools, and I have grandchildren now. And I was thinking about that experience as a parent of a school child coming up here last evening, and there were two crises in our following our daughters through the education system, two that were so great that we had to literally pull over to the side of the road to hear the news. The first was when our oldest daughter was in kindergarten. She was our only child, and you know how it is when you have your first and only child, our precious possession, and she's in the back seat of the car in her car seat, and we're going off to dinner someplace, and we're driving along. I know exactly where I was. And I said, "How was your day at school today?" And she said, "It was great, Dad. I learned what the F word is." This is my little girl. She's in kindergarten. And I said, "What?" She said, I know what the F word is. And we literally pulled over to the side of Rosemar Road in Vienna, West Virginia. That's where we were. I know exactly the spot. My wife and I are looking at each other just like, oh, my goodness, our little girl's been exposed to this. And we pull over, stop the car. I turned around, and I said, "Tell us what the F word is and who told you this. I'm already got in my mind, I know the teacher I'm going to assault the next day and confront about this." And she says, "Fart." Woo! The other one is really more related to what we're doing today. I was driving across the Kanawha City Bridge. I live in Charleston, in the East End, down by the Capitol. And we were going over to Kanawha City with our youngest daughter, who was then maybe in junior high school. And we're driving along, and she says to my wife, "Are you going to tell Dad what happened today?" And my wife kind of quieted her, and I said, "No, what happened today?" She said, "You don't want to hear this while you're driving." And so let's wait till we get to the restaurant. Instead, we pulled over to the side of the road because I was very concerned about what this was, and shut off the car and said, "Tell me what happened at school today." And my wife said, "Well, they had that exercise that they have in school from time to time where they ask students to think about what would happen if you were in a rowboat out in the middle of no place trying to get to shore, and you discover that you have to throw one person from the rowboat overboard or else the boat's going to sink." And she said it was you, and it was me, and it was our other daughter, and Caroline in the back seat. And I said, "Oh, no." And she said, "Yes, they threw you overboard." And I immediately contested that and said, "Well, I've got the strong arms. I could row the boat. I kind of have a sense of direction. If we're out there a long time, I could figure out how to fish, but you threw me overboard. Why was that?" And she said, "Because I know that's what you would do," which is probably so. We need all hands on board, in my opinion, as we go forward with this shared vision I hope that we have for public education in West Virginia. We need to look at who's on the boat. The option isn't always, or isn't the rule, we have to throw somebody overboard when the boat's going down. One of the questions I raised with my daughters was, what if I stayed there and the four of us put our heads together and figured out a way that we can all survive and get to shore? Maybe we'll take turns jumping out of the boat and swimming behind it so that it's never too heavy and sink. They didn't buy that, but I thought that was a pretty good suggestion. How do you know? I didn't have a cell phone. We don't have cell phone coverage now, but we might get someplace and we could get help, and now the cell phone's going down with me. That didn't make any difference either. But I want you to think about this. This is all too important to be taken without all hands on board. And we have a lot of hands that should be on board as we go forward. The lawyer in me wants to tell you, and I will today, about a couple of those hands that need to be on board as you go forward, okay? Not only as we form our vision for public education in West Virginia and what we're going to do to improve students' lives, but also as we implement it. Benjamin Franklin said, "Well done is better than well said." And we have a habit, and we're not alone, in talking a good talk, but not always walking the walk and getting things done. And I'm going to suggest to the legislators here today that your most important ally and helper in going forward is the State Board of Education. I don't represent the State Board of Education. In fact, I've represented county boards of education that had bones to pick with the State Board of Education and the State Department of Education. But I was told to make an objective presentation here today about information that I would want to have if I were a member of the legislature venturing into these waters. And I'm going to show you here something that many of you may not have seen. I don't know how you do everything you do. Frank made a reference to the fact that we're talking about education today, but he knows you have a lot of other things on your plate. So you may not have seen this before, but I'd like you to know about it before you take off without the State Board in the boat, or you throw them overboard along the way, only to find things complicated down the road. So from a legal perspective, that's important. We don't want to create situations where we get into legal snaggles, and some of us have heard talk about that on some of the very issues that were mentioned here today, about vouchers and charter schools and some of the other important issues that we face in public education right now. And as a process matter, I can't help but think, and I hope to demonstrate here today, that the perspective and the expertise and the assets that the State Board of Education can bring to the table, and the perspective and the resources and the expertise that the legislature can bring to the table have to make for a better product. We talked about diversity before. I think we all know, we've heard, it's been proven to us, that the more different views we have around the table, the more different perspectives, the better the final product will be. Even if we don't all agree, the final product is almost inevitably better when we've had frank and candid and open and honest discussions about things by people who don't all share the same perspective. Now, one thing that you may or may not know, based upon your background, is that most of the actors in the government side of public education, the entities and the officials, are there only because the legislature passed a statute creating them. And so the legislature at its next session could pass a statute abolishing them or changing them. County boards of education are created by 2 sentences in the West Virginia Code. And if you were to repeal both of those at the next session, poof, they go away. You look at the West Virginia Constitution, it doesn't create county boards of education. It doesn't create county superintendents of schools. It doesn't create REISs, Office of Education Performance Audits, multi-county vocational centers, the Center for Professional Development, the School Building Authority. All of those entities in public education exist. We say they're creatures of statute. They exist because the legislature, at one of its sessions, passed a law that created those entities, and the governor signed it, or it became law without the governor's signature. And the legislature can just as easily take them away or modify them because they're creatures of statute. That is not true of 2 of the other actors besides the legislature when it comes to public education in West Virginia. They are both created in our Constitution. And you can't just introduce a bill and run it through both houses and change our Constitution. As you know, it's very hard to change the Constitution on purpose. The people who wrote our Constitution, the founders, and the people who have amended it in the years since then, purposely made it difficult to amend, because they thought that the principles and the values and the requirements embodied in the Constitution were so important that they didn't want us, in the spur of the moment, in the middle of a debate, to go in and switch it around to change it. And so in order for the Constitution to be amended, a bill to do that has to pass each house by a 2/3 vote, and then it has to go to a vote of all the voters in West Virginia, who by a majority vote can agree to amend our state constitution. That is a long and expensive and arduous process. A lot of amendments have passed in the years since the Constitution was first adopted. A lot of them have gone down in flames. But it's intended to be that way, I think, so that we don't lightly and without a lot of thought and discussion make changes to things that our founding fathers and mothers felt were essential for the proper operation of West Virginia, in this case, education in West Virginia. The State Board of Education and the State Superintendent of Schools were both created in the Constitution. Unless the Constitution's amended, we have a State Board of Education, we have a State Superintendent of Schools, just like we have a legislature. The legislature can't be discontinued except by amending our Constitution. So all three are constitutional institutions: the legislature, the State Board of Education, and the State Superintendent of Schools, which gives them more permanency and really is the basis for my suggestion that you can't go it alone. And times when we have in the past, we've had some legal difficulties. So I'd like to just share with you a little information about this. I assumed, because all I do all day is practice law, that everybody knew this stuff, and they don't. The last major developments happened in 1958, before most of us were aware of what was going on. So let me tell you a little bit about it. This is the exact language of our Constitution with respect to the legislature's responsibility, its obligation, its duty with respect to education in West Virginia. The legislature shall provide by general law for a thorough and efficient system of free schools, period, one sentence. But unlike the two sentences that created county boards of education that you could wipe out in your next session, that's enduring, that's in our Constitution. That's an obligation of the legislature. I think you know that. I didn't know if you knew that it's enshrined in the Constitution the way that it is. And it's so general, isn't it? What does that mean? What does it mean that you'll provide by general law for a thorough and efficient system of education? Each of us probably can have our own definition, our own understanding of what we think that means or what it should mean. Well, here's what it says about the State Board of Education. The general supervision of the free schools of the state shall be vested in the West Virginia Board of Education, which shall perform such duties as may be prescribed by law. So over here we have the legislature providing by general law a thorough and efficient system of free schools. And here in similar general vague language, we say that the State Board is vested with the responsibility to generally supervise the schools and perform such other duties as may be prescribed by law. Little trivial aside here, we didn't have a State Board of Education in our Constitution until 1958. The voters in 1958 amended our Constitution to put that provision in it. Until then, that provision said the State Superintendent of Schools shall be vested with the supervision of the schools and performing such other duties as may be prescribed by law. Until 1958, we elected the State Superintendent of Schools. Can you imagine what we'd end up with today if in a general election we had to elect the State Superintendent of Schools? That was changed in 1958. And as an example of how difficult it is to amend the Constitution, the same amendment was on the ballot in the 1940s and went down in flames. We had a very strong state superintendent who persuaded people that it was important that the state superintendent have a political constituency and a political base in order to deal with the other organs of state government. And that went down in flames in the 1940s. It was in 1958 when Article 12 of the Constitution was last amended to enshrine the State Board of Education with these responsibilities. And in that year, they included and added to the law the requirement that the State Board select the State Superintendent of Schools, who serves at the State Board's will and pleasure, and he shall be the chief school officer of the state and shall have such powers and shall perform such duties as may be prescribed by law. That's a little clearer. These are pretty vague. Now, you keep seeing this reference in both these last two, to perform such duties as may be prescribed by law, and you may be thinking, we make the laws. We'll pass laws and tell them what to do, and then this means that they do it, right? The State Board will perform the duties that we include in the legislation that we pass, and the State Superintendent will do the same thing. But think about this. These are enshrined in the Constitution. Nobody can take these duties away from these people and bodies, and they can't shirk their duties. They're as responsible as the legislature in their own domain for public education in our state and the education of our children. Now, what do we make of these powers? I've heard people say, well, this means that the legislature, kind of like a CEO, decides what we're going to do, tells the State Board, they're the COO, the Chief Operating Officer, And that's how education's supposed to work. I've heard people say that the legislature cannot tell the State Board of Education what to do. We'll do what we think is best. And if you disagree with us, tough luck. We're in the Constitution and we have the right to do this. And I've heard legislators say, no, we will tell you what to do if we even want to involve you, and you'll do it. And oddly enough, when we have a dispute as to what a constitutional provision means in our state, and anybody goes to court about it, it ends up in our state Supreme Court. And the state Supreme Court looks at vague provisions like these that we see in our Constitution in the context of whatever factual controversy has arisen, and they make decisions that tell us a little bit about what the court would tell us today, I think, those provisions mean. But here's another interesting point. It's never been clarified to the point that on any given issue you can say this is the legislatures, this is the state boards, this belongs to both of them. Nobody's pushed it that far. The cases we have are cases on things that were important to the people that were involved, but in many cases were small in the scheme of things. You look at it this way. And by the way, before we get to the powers, I've kind of compared things here. And here's a question. This would be a good question for you to discuss at your table at dinner tonight or during a break. Why in the world would we give 134 members of the legislature the responsibility they have in the Constitution? And then why would the voters turn around and just have 9 people be responsible for making the decisions of the State Board of Education? What is there about the size of the body that's making the decisions that tells us something about what was intended here? And what about the fact that legislators get a salary and then per diem, and state board members only get a per diem? They're not on the payroll, shall we say, with the salary. What are we to make of that? And what of the fact that state board members have 9-year terms, but legislators just 2 sentences, yeah. And legislators have 2 or 4-year sentences, yeah. What's that about? Especially when you know our governor serves 4 years, at most 8 years. You could have people that outlive the current governor, although at the rate they're dropping on the state board, that won't be true this time. Education employees can serve in the legislature. I'm sure a number of you work for school districts. Members of the State Board of Education can't work for any public employer, much less education. Why would that be? I think those are questions that, when you dig down into them, tell you something about what was intended by this amendment to the Constitution that put the State Board of Education in the Constitution and constituted it the way it did. Unlike the legislature, members of the State Board don't have to come from particular counties. They have to come from congressional districts, but those are large territories. There's probably many people who don't feel as though they have a representative at the State Board in the same sense that they do a representative or a voice in the legislature. But our courts have on several occasions had to figure out what this means. And in a given case, does a state board action take priority over a legislative action or vice versa? I'll just give you a few snippets here, and we'll make this PowerPoint available if you want to see the exact quotes and use the resources. But we had the big direct decision. Remember that case? Started in the early 80s. I had a niece who was born after the REC decision started, and the REC case was about correcting inequities in the way kids are educated in West Virginia based upon resources in the different counties. She was born after that case was filed, went all the way through elementary school, junior high, high school, and college, and became a teacher, and that case was still going on. It didn't get resolved until the mid-2000s. And that case was a huge case, and it's responsible for a lot of the superstructure and infrastructure that we have in education today. But in the course of it, I went through the opinion the other evening. I said to myself, did the court say anything about these respective powers that would help us understand what the legislature's role is, what the role of the State Board of Education is? And the particular decision here, there were a number of Supreme Court decisions in the course of this litigation. Pauley versus Kelly in 1979 the court made it clear that under that provision of the Constitution about by general law providing for a thorough and efficient system of free schools, the legislature is obligated to provide for the support of a thorough and efficient system of free schools. For that purpose, the Constitution gives the legislature plenary, if not absolute, power. In other words, when it comes to funding the public schools, the legislature has no rivals. They have complete authority in this area, according to the language of that decision. And they went on to say, great weight must be given to legislatively established standards because the people have reposed in the legislature such authority and responsibility. So when we're talking about standards for public education, they don't lump that together with appropriating money. When you take care of funding the schools, I read this decision to say that's your business and nobody else's in terms of that final decision. When it comes to the standards, they're to be given weight, but it doesn't say that you have plenary or if not absolute power when it comes to the standards. So I went looking for some other cases. There weren't very many of them. This Detch case that was decided in 1960 was over the issue of whether you had to be 6 by November 1st to go to kindergarten or to get into first grade at that time. The legislature passed a law saying that the public schools shall be open to all children ages 6 through whatever. And the state board passed a policy saying, well, yeah, they're open to kids who are 6, but they have to be 6 by November 1st. And there was testimony about why the state board thought that was a wise rule. Well, somebody had a child born on November the 3rd or something like that and brought a lawsuit to compel the school district to let them enroll. And the Supreme Court saw this as a comparison of the power of the legislature to say, if you're 6, you can go to school, and of the State Board of Education to say, well, only some of the people who are 6 can come to school. You have to be 6 by November 1st. And the court upheld the State Board of Education in this area. And it said the State Board cannot be denied its constitutional power of general supervision. It may enact rules to supervise. And when you read that decision, they talk about the people on the State Board of Education having some expertise in education and matters of whether it disrupts the education or the classroom to have kids come in after November 1st and so forth. A little later, we had 2 cases. The Bailey case was out of Wood County and Kanawha County. It involved that 2.0 rule. Kids have to have a 2.0 average in order to play athletics and be involved in extracurricular activities. Wood County thought that was too stringent, and they wanted people to be able to participate in extracurricular activities at a lower grade level or grade point average. Kanawha County wanted to make it harsher, and they wanted them to have a higher grade point average to be involved in athletics and other extracurricular activities. That got to the court, and the court upheld the state board's 2.0 rule, even though Wood County could show that the legislature had passed a law saying it's up to county boards of education who's going to participate in extracurricular activities or not. So you can see there's kind of a conflict there. The plaintiffs in the case were saying, hey, the legislature told Wood County that they could establish whatever standard they wanted to, and that's what they've done. Butt out, state board. And the state board said, well, wait a second, we have to supervise the schools, and we think that there should be at least a 2.0 rule. And the court upheld that in that case. The other case that is like it, the facts are different, is the closest I think the court's come to resolving this issue of is there a dividing line between the legislature and the state board? And that was a case where when an administrative agency in West Virginia enacts rules, they go through a committee of the legislature, which either approves them or disapproves them, before they can actually become official in most cases, and they're filed with the Secretary of State, and then we have to follow them. The State Board of Education didn't do that. From 1958 up until the decision in the 80s, and in the 80s, the legislature said, we're going to review your rules too. And if our committee doesn't approve of them, then they won't become rules. And if it does, then they'll become filed. The late Secretary Heckler's name's in there because as Secretary of State, he decided to go along with provoking the court to decide this case. He refused to file rules that the State Board of Education promulgated because they hadn't gone through the legislative committee. So the court was faced with the question of, can the legislature make the Board of Education subject its own rules to review by the legislature? And in that case, the court said no. The legislature can't do that. It's infringing the authority of the State Board of Education. And so the language that comes out of those cases that I think is crucial, it says that any statute that interferes with the State Board's general supervision of the free schools is void. That's what the court said. In the Heckler case, he said general supervision is not just an axiomatic blend of words designed to fill the pages of the Constitution. It's a meaningful concept to the governance of schools and education. Decisions that pertain to education must be faced by those who possess expertise in the educational area, and that the citizens conferred this power on the State Board. You know, that fleshes it out a little bit, but it really doesn't help us again. Where does the supervisory power of the State Board start and end? Where does the legislature's responsibility to provide a thorough and efficient system of education start and end? The court said, unlike most other administrative agencies which are constituents of the executive branch, the board enjoys a special standing because such a constitutional provision exists. That the branches of government are separate, and no branch of government is allowed under our Constitution to interfere with another one. So that's the state of our understanding today of the relative roles of the State Board and the legislature. They're not really clear. I think an argument could be made that that's a good thing, but they're not really clear. And we might jump to the conclusion that that sets up a controversy, a fight between the State Board and the legislature at every turn, and it hasn't. The legislature and the State Board of Education, for the most part, have worked collaboratively and very well together. And one of the reasons is what I call the bridge statute. The legislature didn't have to pass this law, but it did, and it says the State Board shall exercise its general supervision, and it will promulgate rules to carry into effect our laws, and then it listed the ones that it specifically recognizes the State Board of Education is to enact. It says the State Board is to adopt rules regarding the standards for performance and measures of accountability, for the physical welfare of students, for the education of all children of school age, for school attendance, for evening and other part-time programs, extension work, classification of schools, issuing certificates to teachers, distribution and care of instructional resources by the county boards, general powers and duties of the county boards, teachers, principals, supervisors, and superintendents. All those things the legislature voted to empower and tell the State Board of Education to do. And then look at the catch-all. Such other matters pertaining to the public schools as the State Board considers necessary and expedient. I read that as evincing a great deal of trust in the State Board of Education and between the State Board of Education and the legislature. Why would the legislature, if it was jealous of its powers or disrespected the powers of the State Board of Education, enact a statute like this that basically says, State Board, do what you think is right when it comes to public education in West Virginia and the policies that you pass? That same law authorizes the State Board to approve alternatives to the letter of the law when it comes to plans that counties have for optimizing student learning. Actually says the State Board can excuse county boards from following statutes passed by the legislature that have to do with optimizing student learning. And it says the State Board can approve such alternatives as proposed by a county board or school if the State Board believes that it meets certain general standards that the legislature put into that law. So I'm going to suggest to you that the State Board and the legislature are clearly partners in this enterprise. They have opportunities, and I'd rather look at opportunities than territories here. And there's a lot of room here for people to make mischief who disagree vehemently with things that the State Board does or that the legislature does, just as the plaintiffs did in these other cases. As a lawyer, my highest value and goal in practicing law all these years has been to persuade clients to take actions to prevent lawsuits, where lawsuits can be costly and damaging and take a lot of time. And I really think that under these circumstances, a lawyer would tell you, reading these legal authorities, the wisest thing for the legislature and the State Board under today's circumstances with some of these huge issues we know that will be discussed and considered in the upcoming months and years, is to work collaboratively, to work with each other. I don't know how many of you have ever sat down with a legislator, I'm saying to the state board members, or vice versa, to the legislators, have sat down with the school board member and talked about these things. I know time is precious, and many times we don't have the time to do that. But I still think in our state, a special thing about our state, it's kind of like that 1 degree of relationship that was talked about before. We still can stop and talk to each other and have a good conversation. So I want to close with the turn signal. I live in the 1500 block of Virginia Street in Charleston, down by the Capitol. It's that long block. At one time, it was the longest residential block in the world. It's one way. There's one lane of traffic through it with parking on both sides. I'm at the office one night. My wife and I had to go to something. It was one of her events, and I promised I'd be there at a certain time. And I was late getting out of the office to go home. And she'd already called me 3 times. I finally let it go into voicemail for fear I'd be in trouble. So I grabbed everything, ran down, got in the car. Mind you, I don't countenance speeding, but I'll push it right to the speed limit, which was like 25 in the historic area of Charleston. And I get to the beginning of that long block, and I live at the other end of it by the Capitol. You've all been on that street. And there is this car in front of me that's going 5 miles an hour, I swear. And I'm just spitting mad. I'm trying to get home. Of course, I created my own problem. But they're going 5 miles an hour. Then they kind of stop, and they're looking out the windows. And I'm thinking, come on, what's going on here? You know, and I know my wife's going to be calling me in any minute, and I've got to get home. And for the first time in my life, I almost sat on my horn at somebody. But I kind of pulled back from it. And we go all the way up the street that way. It seems like it took an hour to get to my house. And we got it to my house, and we share a driveway with the people next to us. And this car pulls into that driveway. It was our neighbors that we shared the driveway with. They'd gotten a new car. I didn't recognize them. And they were kind of trying it out. And I thought, thank goodness I didn't make a jerk of myself. They're nice people and did all kinds of nice things for us. It makes a difference when we get to know people as people in our state. I'm sure it does in others too. And I would hope that in the debate and all the hubbub of upcoming legislative sessions, interim and real, and meetings of the State Board of Education, that we can find time and make time to talk to each other as people and say, hey, you've got a perspective about education we don't have. We've got a perspective you don't have. We can bring money to the table. We can make other state agencies help out. We're elected by people in all the delegate districts and the senatorial districts. We can tell you the pulse of the people out there. And you bring to the table your expertise in education. That's why you were appointed to the state board. Your direct connection with county boards of education and multi-county centers because the state board supervises them. And together, we may not always agree, but Carl Hatzel, who works for the university, brilliant man who teaches facilitation and decision-making to groups, taught us at the law firm a long time ago that when you make a decision as a team, at the end you vote. And if you're thumbs up, that means you're all in for what's been decided by the group. If it's thumbs down, you're not. If you're thumbs sideways, you're saying, hey, we had a good process. We can't always agree, but I think our process was fair. Everything was taken into account, and I will support it, not because it's my choice of options under these circumstances, but because it came out of a good process. We're not always going to agree. The best experts in education can't agree about what we should do. How would we expect our legislature and our State Board of Education to do that? But we can talk to each other, and we can listen and not lay on the horn. In closing, one of my heroes in history is Helen Keller. And I don't have to tell you about the challenges that she faced. This is what she said, and I think it says so much about what we're about to do in making decisions about public education in West Virginia. Alone, we can do so little. Together, we can do so much. Thank you.
We're kind of tight. If it's okay, we take 2 minutes for a question. Sure, go ahead, Cindy.
I got a microphone. Let me give you a microphone.
I didn't know you were going to touch upon legislative rulemaking oversight, and I was going to ask you at the end. So since you did touch on it, the executive is a separate branch from the legislature, and we basically have oversight. They have the right to promulgate rules, and we have oversight over those rules. So what is different with the school board, not having the legislative oversight?
I can't tell you what the court would say about that. I do know that the linchpin of the court's decision in the case involving the State Board of Education was that the State Board of Education is a fourth branch of government for all practical purposes. I don't know whether the court, faced with the same issue with the other administrative agencies, would say that we won't interfere with the governor's rules and edicts and directives, but we will of the Human Rights Commission and the other agencies that we created as a legislature. I don't know. I don't know. I just read the tea leaves by looking at what the court has said.
Because I sit on that legislative committee, and we often, always when we pass laws, we give the executive the right and the agencies the right to promulgate, and we oversee all agencies, to my knowledge, and commissions and boards.
And I'm sure what you're saying was probably an argument that was made to the court in that case. It makes sense, but it's not a line of reasoning that they followed with respect to the State Board of Education.
Okay, well, thank you.
Okay.
When I hear that, like when we had the bills dealing with Smarter Balance and Common Core, and it came up, I was on Education Committee, this whole question about the article of the Constitution. Obviously, the Department of Ed took the position that you presented as the historic position. Were they, I mean, I'm not going to say were they right or not, but we, in the doing of the Common Core and those bills, we actually were swimming against the tide of where that would have been a supervisory privilege of the Department of Ed and not a play, we would have been pushing in to legislative waters that would have been different or more aggressive and could have resulted in litigation to try to further clarify. But the body of where we are now would have said we had no business doing those laws. Agree or disagree?
Well, I think an argument could be made both ways on this, especially under that bridge statute you passed that says that the state board shall make policies concerning accountability in the schools. We're trained to make arguments on both sides. I think you could make it both sides. I think you're exactly right. A big case like that, it'd be like these tectonic plates that come together in earthquakes, and then we get a big decision. And I don't know if we want that. I don't know if either side wants to get up to the brink and then find out that maybe a decision is made that kind of upsets the status quo. I mean, right now it's sort of a dare you to do this, dare you to not, or let's work together. Think how you work together on solving the wrecked case. That involved all kinds of legislation in order to change the school aid formula and create the school building authority, do other things to solve that litigation. And the State Board of Education had to pass all kinds of policies, unlike any policies that's ever passed before. The court would not have let that case go away. Think of what you did as a legislature and the State Board when it came to intervening in the operation of school districts that are not performing in a satisfactory manner. You authorized the State Board to take control of those school districts and gave them some tools, and then they passed a policy that fleshes that out. You work really well together. And I don't want to emphasize the conflict over the areas where you do agree, but it would be irresponsible in a setting like this where we're supposed to be giving objective information to not alert you to the fact that there is that questionable area that maybe somebody will venture into and get it resolved for us. And you know there are people out there just waiting to bring a lawsuit on some of these issues because people feel so passionately on both sides. Thank you, Mike.
Thank you once again, Howard. Thank you very much. Howard.